highest Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Okay. We are here for our final argument of the day in cases consolidated under number CV21-0638, Coyote versus Icon et al. So we're going to record and live stream these arguments, which means it would be helpful if you, when you stand, you give your name and the name of your client. I see multiple people signed. Are you all planning to argue today? Well, I wish you luck with that. That never worked for me in private practice. But to be clear, there is 20 minutes per side maximum, and it's your responsibility to keep your time on the podium, and we look forward to watching you engage in that negotiation. We have read the briefing. We have reviewed the substantial record. We discussed the case in conference this morning. And with that, go for it.
Thank you, Your Honor. Good morning. May it please the Court. My name is Jeremy Hanshu. I represent the appellant, Coyote Logistics, along with my co-counsel, David Cash. This case presented before this Court presents issues involving interstate motor carriage. And the bedrock rule for purposes of interstate motor carriage is that the motor carrier gets paid. This case will have a profound effect upon the well-recognized and uniform federal rules that apply to the obligations arising under a bill of lading, which is just essentially a basic contract for transportation in interstate transport.
For a bill of lading to be a contract, don't both sides have to have desired for it to be a contract?
Your Honor, for here, there have been interjections from defendants that despite meeting all the requirements under federal regulations, that these bills of lading somehow didn't meet an additional subjective intent test under Arizona law, but that is not required. Instead, it's an objective intent based upon the express terms on the bills of lading, which are...
So the documents you're referring to, we looked at them, and they are effectively tracking sheets. There's no description of obligations on the part of people, companies to the document. It's just hard to see that as a binding contract that would jump over the lack of any other privity between these parties and Coyote to bind them to pay, again, for services that they pay for.
Your Honor, understood. These are a type of contract whose terms are very basic. They've been around for a very long time. Early 20th century, they've been developed. To your exact point, one particular defendant in a case asserted that, well, those don't have the same additional contractual terms in the Southern District of New York case of grocery haulers. There, the court said, this meets all of the requirements under these bills for the terms prescribed by the federal regulations for a valid and enforceable bill of lading, and stated, I reject your contention that more is needed. They're simply to facilitate commerce. And
who prepared these bills of lading?
They were prepared by wholesale, but they were used by all of the motor carriers during this project.
And the motor carriers, so it was the wholesale prepared them, and then it's the motor carriers that Coyote arranged to transport the waste.
This project involved 50 million tons of CRT, yes. So this is, Coyote only had a part, albeit 250 truckload shipments, so each truck holding about 40,000 pounds, so a significant amount for a Coyote. So the motor carriers that Coyote arranged used them, as well as the record reflects Transchem used them, as well as other motor carriers that are arranged by Transchem as well. So they weren't limited to just wholesale.
But they would have been between wholesale and Transchem or wholesale and Coyote. At what point Can you point me to a place where these are somehow binding between Transchem and Coyote?
We are not pursuing relief under count 1 against Transchem. That's the motor carrier
right.
hired by Icon, the shipper.
Sorry.
And so the
I have a
contract.
chart, but sometimes I get off.
Sure, I understand, sure. So regardless of any relationships contractually between Icon and an intermediary such as Transchem, you still have this separate bill of lading, which is basically a contract between the shipper, the receiver, and the motor carrier.
Okay.
And quite, Your Honor, Congress has stated when it passed ICTA and deregulated the industry that while it was removing the requirement to file a tariff, which is essentially the terms and conditions that govern the transportation, that was no longer required following ICTA. However, Congress very specifically stated that since motor carrier transportation is truly an interstate industry, it's critical to the smooth functioning of commerce that there be federal commercial rules established to ensure that all interstate transportation is subject to the same rules and procedures. Otherwise, a motor carrier will be potentially subject to 50 different rules for operation. And it's Coyote's position that when looking to the grocery haulers case to find that if you have the bills of lading with the requisite information, that is an enforceable contract, and there's a principal intent to have uniformity without the requirements of 50 different states for additional terms. Your Honor.
Does that include someone who's authorized to sign those bills of lading? I mean, generally, when we hold parties to a contract, there's offer and acceptance by the party, someone who's authorized to accept the contract. And isn't that a big hole in this case? Even if we treated those as bill of lading, is there any evidence in the record to say that the people signed it were authorized on behalf of the recipients of the benefit to sign these contracts or enter into these contracts?
Your Honor, there was no preservation of any such issue in the lower court. However, there's Arizona Feeds, the one case in Arizona which recites the common law rules that apply to bills of lading, simply sets forth the rule that the shipper named in the bill of lading is primarily liable for the shipment of the goods. And here we're not dealing with an action to enforce for untransported goods or damages. We have actual performance. So there's no dispute that, in fact, the goods were shipped from...
Your point is that these bills of lading, or receipts, or whatever we want to call them, created a contract between your client and people who were otherwise not in privity with your client. So you just issuing the bill of lading without someone signing it makes them liable?
Your Honor, we were assigned by each motor carrier who executed the bills of lading, along with the shipper's execution and the receiver's execution. We stand in the shoes of the motor carriers, my client does. Coyote did not sign or issue these bills of lading. Instead, they received an assignment. So for all intents and purposes here, we are the assignee of the rights under the bill of lading. However, to answer your point, therefore, each motor carrier was listed on the bills of lading, executed it along with the performance by Icon, the performance by the motor carrier, and the execution by the receiver, which Arizona Feeds instructs that the receiver becomes a party to that contract upon acceptance of the freight, perhaps to allay your point, not just by being listed in the bill of lading, but by that act of accepting the freight. Therefore, they become subject to the terms of the bill of lading. That obligation of the consignee is secondary to that of the consignor, and here in this case, it's undisputed that U.S. Ecology never paid any amount to anybody for the benefit of the transportation services that underlie the bill of lading.
Wait, I'm sorry. Maybe I'm missing up my parties. It is undisputed, though, that they paid the $329,000 to wholesale, right?
That is Transchem. So you have Icon who had from its...
That's the entire amount that was due under the contract. even if the other party didn't pay it, somebody paid that $329.
From Icon, they used the insurance proceeds from the tenant to paying Transchem. Transchem in turn paid wholesale, and then wholesale failed to pay Coyote. However, just in point of fact, no payment has been forthcoming in this record from US Ecology at all. And I'm just pointing out that.
And they're liable just because of the bill of lading. That's the theory.
Arizona Feeds in tracking with.
Would you be entitled to get payment from them even if you had got the $329?
No, Coyote has always maintained a position we're entitled to a single recovery. We're not seeking double recovery here, but we have alternative theories both against our contractual party wholesale, but also against those who are party to the bill of lading via assignment.
And maybe this is just me being dense, but what would prevent you from seeking double recovery, though? If everybody on the bill of lading is entitled to it, or is liable for it.
My opposing counsel friends wouldn't permit that, and it came up in discovery, and it's simply not an issue here because it hasn't occurred.
But why do you refer to joint and several liabilities? Isn't that what it means?
The joint, to be frank, Your Honor, it is, and we modified later, it's simply joint. We are not seeking the several component.
Okay.
I point out, and I will reserve 6 minutes of my time for rebuttal, that this theory which exists under the common law and by statute is recognized by the secondary sources in this area, just the fundamental precept that the bill of lading is the contract for transportation, and the rules set forth in Arizona Feeds explain how under the common law those obligations lead to both primary and secondary liability. Second, and importantly for purposes of this case, we had an issue where, for purposes of payment, in the interstate transportation context, the federal courts of appeals who have addressed a payment defense have found, given Congress's policies of ensuring a vibrant and sound economic system for motor carriers, that payment is not a defense and that the shipper may be subject to liability for double payment.
What is your best case? And I realize you cite more than one, but what is the best case for a scenario similar to this one, where it's undisputed that somebody was paid in full and they ended up being solvent, and so that the shipper down the line didn't get paid and was able to recover from the people above?
Your Honor, given this court should look to the Ninth Circuit, I point out specifically the Oak Harbor case. It's post-deregulation, and it sets forth that same principle, and it states that, look, these rules under the bills of lading can be modified, and it's by various mechanisms, whether it be a lien waiver, whether it be marking the bills of lading prepaid or freight collect, or other modifications dealing with a reputable intermediary or contracting with the carrier in the first instance. None of those modifications were undertaken by the defendant, so the default rules still apply in that context. So it's not without some opportunity for the shipper and receiver to protect themselves. It's something that they have the burden to undertake in that context. In addition, we have a claim given Transchem's involvement here, which Transchem is a motor carrier, and its license permits it to transport as a motor carrier property in interstate commerce. However, it is prohibited under MAP 21, which is recent legislation in 2012 passed by Congress, from engaging in any broker services. A broker service is not motor carrier transportation itself, but it's someone who holds a specific license to arrange for the transportation of freight in interstate commerce. Here,
what is your authority for the proposition that even if we assume they were acting as a broker and that it was prohibited, that would entitle you to contractual damages here?
Your Honor, we do not pursue contractual damages, but rather the remedy that's set forth in 49 U.S.C. 14916, which states a very broad remedy that if any person, including motor carriers, who brokers without a license, then shall be liable to any injured party, a broad class of injured parties, for any valid claim for regardless of the amount. So it is not pursuing a contractual remedy against Transchem, but rather the statutory one, because Congress sought to stamp out this.
And under that statute, that federal statute, Coyote would meet the definition of an injured party injured by this alleged illegal brokering?
Yes, Your Honor. The text, had they meant to limit the class of who could have been injured to a particular set of party, they would have so stated. Instead, they spoke in very broad terms to capture their policy objective of making sure that this nefarious conduct of brokering and allowing the monies not to go and be paid to the motor carriers to seek redress and remedy in the courts.
But you see here where the entity that you're making this allegation against didn't fail to pay and did attempt to pay the motor carriers and are not the sort of nefarious actor in this case. It seems a little bit outside of what Congress was trying to do there, doesn't it?
To your point, it's not the function of payment, it's this brokerage without a license. And it's very clear that it's that conduct, because that conduct was resulting, based upon their policy decision, in the hiring of other motor carriers. Here, Wholesale was then hired. Wholesale didn't even have an interstate motor carrier license. It couldn't even move freight from Arizona to Nevada, and that's the type of lack of control of who's being tendered freight that Congress sought to eliminate by requiring, if you are to broker and arrange or subcontract, you must have the license.
Wait, you added a word there. Subcontract equals brokering?
I think in the context...
Or did you just add that to the context?
That's my attempt to make an analogy to other contexts. The arranging freight sometimes can
There's
just...
no prohibition against subcontracting.
If the subcontracting is arranging freight in the vernacular of a motor carrier's hired and then they, quote, subcontract it to another motor carrier, that's the equivalent of brokering because they've arranged for that second motor carrier, and that's the conduct that's prohibited. Now, the language of the statute speaks to arranging. I simply draw upon some of the construction industry terminology as a reference. And so, returning to my earlier point, here we have Congress's intent to create uniformity, to ensure motor carriers are paid, a basic transportation contract, a bill of lading, where the shipper is primarily liable, the consignee is secondarily liable. There's no double payment defense in this limited context of interstate transportation motor carriage. And then lastly, in addition to ensuring motor carriers are paid, Congress wanted to ensure that there was a remedy to those who were an injured party based upon an entity such as Transchem from brokering without a license. We've heard that, well, it doesn't matter if I brokered so long as I retained my status and represented that I was a motor carrier. MAP 21 specifically addresses that in 13902A6 and says motor carrier cannot engage in the brokerage service without a license. And with that, Your Honors, I reserve my time.
Good morning, Your Honors. Craig Law with DLA Piper for Icon Owner Pool 1 West Southwest LLC. So we have 3 counts. The first one dominated the amount of time that Mr. Hanshew used just now, and I want to spend probably less time on that than some of the other counts. One thing that's worth noting, Mr. Hanshew referred multiple times to the terms of the bill of lading. So it's the terms of that bill of lading, which is an alleged contract in this case that his client seeks to enforce against Icon and U.S. Ecology. There is no contract in this case titled the bill of lading. What we have in the record are shipping papers that were used by the carriers who went to Icon's property and collected the waste to transport to U.S. Ecology's dump site. And they're in the record at document EIR 138. That's Exhibit 2 to the second amended complaint. And this was a package of materials that Coyote used as an example of here's the contract we're alleging, or here is what we're basing our count 1 on. It begins with an invoice from Coyote to U.S. Ecology, from Coyote to wholesale. And that is the party that Coyote actually contracted with for its brokerage services. It continues with one of the two things that Coyote purports to be a bill of lading contract in this case. And it's nothing more than a simple hazardous waste manifest, which, as we noted in our answering brief, page 30, footnote 4, a hazardous waste manifest is legally required under 49 CFR section 172.205A to accompany all shipments of hazardous waste in interstate commerce.
Counsel, do you agree that bills of lading do create a contract?
I agree that they can.
Okay.
But it
what is missing from this one that is required under the federal regulations or common law or statute for a bill of lading?
Your Honor, there is no federal requirement as to what a bill of lading must contain to become a binding contract on parties. The contract claim itself is still subject to state law. So there's no federal statute, there's no federal case that says a bill of lading is an enforceable contract if it contains the following. What there is there is a statute that says that a motor carrier must record certain minimum information on either a bill of lading or a receipt, because these things are used for tracking purposes and for record-keeping purposes. And so what we have, and there's the reference to the grocery haulers case, is you have a statute that says that there must be this minimum information contained on a bill of lading or a receipt, and then you have an argument from Coyote that since the hazardous waste manifest, or also part of Exhibit 2 to their complaint, a load and unload form, which merely reflects that the truck was loaded and unloaded, contains that minimum information and therefore must be a bill of lading, and then tries to bootstrap case law to say that a bill of lading is considered to be a default contract if the parties do not agree to create a different contract. What's missing from these documents, these shipping papers, the waste manifest and the load-unload form, is any agreement whatsoever or any specification whatsoever as to the rate for carriage or the charges for the transportation services. So we have the basic elements of a contract under Arizona law. There is no breach of contract claim asserted in count 1, fundamentally. For them to try to create a contract out of these two very different types of shipping papers, they would need to be able to show that those papers contain the necessary elements of a contract. And here, they lack any information whatsoever with respect to the specific term that they're trying to enforce against Icon and U.S. Ecology, which is the charge or the freight rates. There's nothing whatsoever that binds any party in those papers to such an agreement. When they refer in their opening brief and in their reply brief and in the record below in their papers to they're seeking to enforce the rights to collect freight charges arising out of these documents, again, look to Exhibit 2 to their Second Amendment complaint. There is no right arising from these documents to payment for any sum because it simply doesn't address those things. This is a tracking paper that's required to accompany shipments of hazardous waste. That has absolutely no terms about price or other terms and conditions. It simply records the weight and other basic information about the hazardous waste being transported. And a load-unload form, which confirms that someone came, picked up the waste, and then someone unloaded it at the dump site. So we have a fundamental lack of a contract. But also important in count 1 is that there was no breach of contract claim asserted. And so appeals to two federal statutes that have nothing to do, that don't grant a right of action, references to two Arizona statutes that do not create a right of action, and broad references to federal or state common law do not allege a cause of action. And that is primarily what the Superior Court relied upon in dismissing count 1 and then granting summary judgment to Icon and U.S. Ecology on that count. the record, the decision from the Superior Court is clear that part of the decision below was based upon arguments made by ICON, first in its motion to dismiss the count, that weren't responded to by Coyote. And so in that minute entry, you'll see that the Superior Court refers to the fact that things were alleged, there was no response from Coyote, and the court found that those arguments had merit, so that there is a waiver issue as well in the record. Count 2 for unjust enrichment is resolved by cases from this court, where the court has found that in a situation where you have one party who's in contract with another, makes payment in full to that party.
Count 2 is not against your client, but since you've raised it, I'm going to ask you, what do we do with the federal case law that Coyote asserts doesn't recognize a double payment? Because that's what our cases are kind of relying on, is this no option for double payment. But what do we do with the federal case law that Coyote is pointing to?
Well, Your Honor, what we have is a state law claim for unjust enrichment and quantum merit. And so...
And the fact that this is occurring in a interstate transportation context doesn't impact that?
It doesn't supersede that at all. And in fact, one of the cases that considers this had to do with a pretty similar situation, not interstate freight, but simply it's the leasing case in which Advance hired someone to, I think Advance was actually the leasing company in that case, but the fact pattern is pretty similar. You had a property owner who hired a general contractor. The general contractor needed to use a crane for its services and subcontracted with someone to get the crane, that's the plaintiff in that case, and didn't pay that subcontractor. The subcontractor tried to sue the property owner for its charges, and that claim was rejected as an unjust enrichment claim because the property owner had paid in full its general contractor for those charges. Similar situation applies here, where ICON hired Transchem to transport all of the waste, paid in full for all of the freight charges and other services Transchem offered. Transchem, in turn, hired Wholesale as a subcontractor, paid Wholesale in full, and there's no dispute about that. And then ultimately, Wholesale engaged Coyote and didn't pay in full. The same law applies. And briefly, I would like to address the brokering claim. Brokering is defined in the federal statutes specifically to exclude a subcontracting arrangement. And there are multiple cases cited in our briefing that make that point very clear. 49 U.S.C. 14916 is the statute that prohibits brokering, and 49 U.S.C. 13102.2 defines what brokering is, and that is selling or holding oneself out as selling or arranging transportation by motor carriers for compensation. We cited to the Essex v. Barrett case, as well as the Asarco versus England Logistics cases, which are both post-MAP 21 amendment cases that recognize that subcontracting services is not prohibited by the broker statutes, provided that the party subcontracting assumes the legal responsibility for transporting the goods or materials. In this case, there is no dispute under the services agreement between ICON and Transchem that Transchem took full responsibility for transporting the waste in the first instance. It's subcontracted then to Wholesale to assist it with that transportation, but it fits right in line with Essex and Asarco in that it took the legal responsibility for making that transportation happen, and therefore was not acting as a broker, not holding itself out like Coyote was to arrange for others to do the work. Two other very brief things. I want to allow some time for my co-appellees. There is another obligation, even if this court were to find that a brokering violation occurred on Transchem's part, where ICON is not liable for that unless it was knowingly permitting or allowing or encouraging that to happen. And what we have is a services agreement between ICON and Transchem in which ICON required, although it allowed them to subcontract, required them to comply with all applicable law. And that applicable law is defined to include any laws and regulations that apply to interstate transportation. There is nothing in the record that suggests that ICON knew that Transchem was in violation of any obligations, and frankly, it was not in violation of any obligations. But without that evidence in the record to show that ICON was aware during the transportation contract's performance of any issues in terms of illegal conduct, it can't be held liable under that statute. The last point I would make is that the damages argument, this is not an injured party under the brokering statutes. They refer to the broker's bond that's required to be posted, and that broker's bond, as we explain in our papers, is specifically defined as something to protect the carrier from an unpaid claim. And so in this case, the only one acting as a purported broker, or the only one whose non-payment could have caused harm to a carrier, would have been wholesales. Everybody else met its obligations under the contracts it agreed to. With that, I will yield my time to Mr. Burke.
Tom Burke on behalf of Transchem, Your Honors. Trying to do the dance here and get some things done. I'm going to try to address a couple of the questions that have come from the panel. Count 1 does not apply to Transchem, but you spent a lot of time talking about bills of lading. The owner and president of Transchem is sitting behind me. He's going to get in my car when we leave, and he's going to tell me again and again, because I've heard it again and again, that Transchem does not use bills of lading. Transchem is a nice Arizona-based company that is in the hazardous waste disposal business. It uses hazardous waste manifests. It does not use bills of lading. And to address the question about Oakmont, I think, Oakmont's a golf course,
Oak Harbor.
Oak Harbor, thank you. Oak Harbor and plenty of other cases, pre-MAP, pre-deregulation, say that a bill of lading, which does not apply here, was not involved here, but a bill of lading is a default. You can contract around and have separate kinds of contracts, arrangements that then dictate how the loss and the risk goes. And you only go to the, I'm sorry, Your Honor, I should know.
Harbor.
Oak Harbor. The Oak Harbor case, you only go to that, as Mr. Hanshu does, in a default situation. And that's not what we have here. We have contractual arrangements among the three parties over here. There's a great divide here. Coyote didn't know of us, and we didn't know of Coyote.
When did Transchem become aware that wholesale referred transportation jobs to other brokers?
Long after the job was done, when Coyote's counsel wrote to the three defendants and said, you owe us money. It was after they sued wholesale in Georgia. It was after the Georgia litigation and attempts to collect from wholesale, which makes sense. Wholesale is the one that stiffed them. And so they sue wholesale, they collect a little bit, but not enough, and then they tee up these legal theories to try to hold the three defendants responsible. That's the first time that we became aware of Coyote. That's the first time we became aware that wholesale had went there. Let me mention one other thing that, as I was preparing, I had actually forgotten about this. If you go back into this second amended complaint, which is the operative complaint, in count 3, Coyote alleges that wholesale was a shipper. If Coyote wants to call wholesale a shipper, it can't get then to this double brokering concept, which is really a concept that doesn't meet the regulations, as I'm going to get into, and I do need to cede some time to Mr. Jacobs, but you can't have it both ways, where Coyote decides, well, I'm going to characterize wholesale as a shipper, and then somehow I'm going to leap over that and recharacterize Transchem, which it says is a motor carrier, into a broker. Mr. Hanshu has said to you, he's argued in his written materials, he argued in the trial court that brokers arrange. Well, so do motor carriers. 49 CFR 371.2, relied upon by Judge McKiddish, understandably, because it says this: motor carriers are not brokers within the meaning of this section when they arrange or offer to arrange the transportation of shipments which they are authorized to do. It says authorized to transport. Transchem was authorized by its contract to transport, in which they have accepted and legally bound themselves to transport. And that's what you have heard and what you see. My client was authorized, accepted, and legally bound to transport for Icon all this waste. Let me give you a quick hypothetical, just twist the facts a slight bit to illustrate this. Suppose that when this big mess in South Phoenix was being cleaned up and all this waste was being sent off to Beatty, Nevada, that Transchem discovers actually some valuable property in there. And Icon says, well, that's our property, so ship that to Illinois. Under the contract, you're getting rid of everything, but take that valuable property. And the valuable property gets transported, unbeknownst to us, by a truck arranged by Coyote. And some loss occurs. Icon is going to come to Transchem, pursuant to the contract, as the responsible party for that transport for its loss under that hypothetical. And that's permitted, and we didn't broker that pursuant to federal regulation. We simply arranged, which we're permitted to do, and we were authorized to arrange, and we accepted responsibility to arrange. With that, I'm going to cede some time to Mr. Jacobs.
The pleading really should guide your honors here. Andrew Jacobs for U.S. Ecology. Their count one, there's no such thing as a claim for joint liability. There just isn't. Case should end there. The things they try to do in count one don't really work for them. It's like the aphorism that an appellant who has 7 issues really doesn't have any. If you go to page 5 of their reply brief, they say, well, you can see what we pleaded, and they say it's kind of like a contract claim. It's a federal statutory, federal common law, custom and practice contract claim. Well, it has to be one thing. It can't be 5. It's not denominated as a contract claim, and it doesn't work as one. As to the federal authority that there was this colloquy about, the Ninth Circuit can't overrule Arizona state common law of unjust enrichment. If you look at their complaint at App 97 to 99, that's what they plead as a state law claim for unjust enrichment. Your Honor's Baker case out of this division has it exactly right. When it's all paid up, there's no claim for unjust enrichment, and there's also a contract that controls the subject matter, which sort of undergirds the law here, because we have a preference that things that are ordered in contract be left ordered in contract. And that's the way this should have been done, but there was no claim pleaded for breach of contract, so you can see the Venn diagram, there's no overlap here. It's a fundamentally contractual matter. There isn't a contract or a contract claim. It doesn't work. There's no bill of lading for the reason my friends over here have said. And ultimately, I can't improve upon the formulation that Judge Perkins started off with. I mean, there's no description of the obligations. There's no description here. I mean, a bill of lading can be a contract. I mean, Craig is right about that. But it isn't of necessity. By calling it a bill of lading, the label doesn't overcome all the things in common law and make it into a contract. So it's not for the reasons that my colleagues have stated, and I'm going to finish up 12 seconds early. Thank you, Your Honors.
Thanks.
Your Honors, briefly on reply, as Coyote set forth in its pleading, the substance of its pleading allegations control. We stated that there was a bill of lading, it was assigned, and regardless of which theory
What
of
is
law,
the substance of count 1?
the motor carriers entered into a bill of lading with the shipper and receiver. They
What
then
is the claim? Like,
It's
what is the legal claim?
an action to recover freight charges on a bill of lading. Breach of contract, a bill of lading is simply a type of contract, so it's just a name. we set forth that we pled there was a bill of lading. We demanded payment after they were assigned to us, and payment was not forthcoming, which constitutes the breach. And there's no requirement for a price term on a bill of lading. We cite even to Arizona authority where it states following performance. Oftentimes, we've asked that this be remanded to the trial court for determination of damages. We're only seeking a liability determination. And so it doesn't matter whether or not it should have been called a breach of contract claim. The substance is there, and we've argued, regardless of the misconstrual that was adopted by the trial court, that these are just separate theories of whether it comes from federal statutory law, whether it comes from state common law, or whether it comes from federal common law. They all set forth the same rules. They're all in harmony. So regardless, when we cited to just the federal law, they stated, well, that doesn't apply to this case. So we said, okay, in the alternative, the common law rules will apply. Exactly what Arizona Feed states.
Counsel, my kids order tons of stuff online all the time, and we get, every day out my door, there's some package on our front step, and it's got a receipt showing that it was delivered on it. There's nothing on there that says, this is how much you're charged and you're agreeing to pay this amount, but I accept these packages into my home. If the companies they bought this stuff from don't pay, am I liable now? Because
in that instance, Your Honor, you would have paid most likely, and this is why it's factually intensive in this case.
right, and they paid.
You paid the shipper for the shipment.
No,
and
I
handling
ordered
fees.
from Amazon, so I've paid Amazon for Prime.
And because you paid as the receiver, you would then have an ability to foreclose a right from the motor carrier if the bill of lading is marked prepaid. But in this context,
So only if it's marked prepaid. Otherwise, I need to start looking at these things and see if Amazon goes bankrupt, whether I'm going to be liable for all these Prime deliveries.
oftentimes it's Amazon itself delivering the freight. But in this context, the contracts control based on the terms that exist on the contracts.
I'll be more careful going forward.
And the FMCSA regs state that used to be okay to broker, now after MAP 21.
Thank you,
very
counsel.
specifically it's
Your
not.
time has run. We appreciate your time and your arguments, and the court is adjourned.